Hi, my name is Lorena Saedi. I am the founder and managing attorney here at Saedi Law Group, and this is the next video in our series about the actual bankruptcy petition schedules. I know, probably kind of nerdy, but if you are filing bankruptcy, then you really need to know what each schedule is in your petition so you can understand how everything fits together. As attorneys, I know we're really bad about just going, here you go, here's this 60-page document, I need you to review it. And that's fine, you can be reviewing it to make sure numbers are right or things are spelled right, but I think it's important for folks to understand how all of these different schedules, how they fit together, and they affect your case, be it a Chapter 7 or a Chapter 13. So today's video is going to be about Schedules G and Schedule H. And the way it works is when you file bankruptcy, certain debts, certain issues are broken down into schedules. So this one, Schedule G and Schedule H, I'm going to do this video together because both of these, it's pretty straightforward, but I want you to understand what gets listed there and how it affects your case. So let's start with Schedule G. So Schedule G is where we are going to list executory contracts. Basically what that means is this is where we list the leases that you have. So, very important, if you have any kind of lease agreement, this can be on your car, can be on furniture, it could be on electronics, it can be on if you have an apartment or a rental home that you're behind on, you want to make sure that you have these listed in this section. Now, it's important because when you file bankruptcy, you're going to list what your intent is with certain things. So if you're in a Chapter 7 case, you want to list out, like if you have a lease for furniture, if you have a lease with a car, you want to check if you're going to assume the lease or you're going to reject the lease. And that gives a heads up to your creditor to let them know if they need to send you an assumption of lease agreement, if you're going to keep making payments, so everybody knows how everything's going to move forward. Because in Chapter 7, remember, you're not restructuring debt in Chapter 7. Chapter 7, with your secured or leased items, you just got to keep paying them directly. And if you don't pay them, they will come and pick up those items because again, that's a Chapter 7, not a Chapter 13. So if you do have a lease, yes, the automatic stay will stop any kind of repossession momentarily, but eventually if you don't pay these items, they're going to be able to come and get them. So don't stick your head in the sand. If you have something leased that you want to keep, you need to keep making the payments. And don't forget, and again, I have a video, it's actually going to be linked in the description below. I have a video about leases and about creditors and about what creditors do when you file bankruptcy because, again, they'll usually shut off your online account access. There's a lot of reasons. It's in more detail in the video that I have, but make sure you check that video out if you want to make sure you know how to handle if you have a lease that you want to keep. Now, leases in Chapter 13, it is very, very important that when we are writing your Chapter 13 plan, we reflect what leases that you are going to assume, because if you don't assume the lease, it's going to be rejected. And that means the creditor can, of course, come and reclaim their collateral. So if you have a leased car, if you have like errands, a rent-a-center, something like that, this is where all of this would need to be reflected in not only Schedule G, but it would also be reflected in your Chapter 13 plan. There's a section that's going to cover any leases that you have, and that's where you would list what arrears that you have, and then what you would be paying to cure those arrears. So Schedule G is where you're going to list your leases. Now, I will get a lot of people will ask me, well, I'm good with my current apartment rent or rental rent, or my home rent, and I don't want to do anything that's going to cause them to not renew my lease. Totally understandable. So make sure that you talk to your attorney so that when we're preparing it, we can select that even though we've got them listed, they're not going to receive a notice of the bankruptcy because they're not a creditor that you're needing to repay or anything like that. You're just going to continue to make that. That really is only going to apply if you have a residential lease. I know these days the landlords and the leasing companies, they're really cracking down on folks that are in bankruptcy and make it very difficult. So I do understand why people get really worried about that. So just make sure you talk to your attorney and make sure that if you're current on your lease and you don't have any arrears and you have it listed there, just make sure that we can basically check a box so that they don't actually receive notice that you filed bankruptcy because you don't owe them anything, so they're not a creditor. So that is Schedule G, and it is very important that you have any leases that you have listed here. Now, let's talk about Schedule H. Schedule H is pretty self-explanatory. It's the schedule that covers co-debtors. And yes, if someone is a co-debtor on a debt with you, you have to give them notice. They have to be listed. And you may think it's silly because that co-debtor is, most of the time, it's your spouse. You're like, well, my spouse already, they know I'm filing bankruptcy and blah, 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 blah. That's nice. They still have to be listed. So if you don't list them, you are going to have to there's going to have to be an amendment to add them into your case. So just make sure when you are providing information to your attorney that you are listing anybody that is a co-debtor. Now, not authorized user, that's different. Authorized user is not a co-debtor, because if you mess up on payments, they can't go after the authorized user. They can only go after the co-debtor because they're the co-debtor. But you need to make sure that they are listed. In addition, if you have questions about what happens with a co-debtor when you file bankruptcy and things they need to be aware of, we have another video on our channel that goes over that in a lot more detail, because that's a biggie. It can be a lot of drama with co-debtors. We get a lot of phone calls, and unfortunately, we're not their lawyer. We're your lawyer if you're one of our clients. So make sure you check out that video so that you can prepare anybody that may be a co-debtor on any debt that you have that's going to be involved in the bankruptcy, so you know what to expect. You can tell them what to expect and try to cut down on some drama when you file. Because a lot of times it's unnecessary, and if someone understands, I'll be honest, a lot of times I send them a link to my video to my client and say, pass this on, and have them watch it, and hopefully that clears things up, which usually it does. But when you have a co-debtor, they have to be listed. So make sure you need to know their name, their last known address. All of that has to be on your bankruptcy schedules because it is required. One thing I try to reiterate to my clients is bankruptcy is not about what you like and what you want to do. That's not how it works. It is a legal mechanism to help you get out from under debt and deal with creditors, but you have to play by their rules. They don't play by your rules or what you like or what makes you uncomfortable or what makes your spouse uncomfortable. That's not how it works. So put that out of your head, because that's not how it works. And so I probably on a weekly basis have to nicely explain that to someone. Like, I understand why you feel that way, but the court doesn't care about your feelings. This is the law. These are the rules. So understand that. And, sometimes folks are like, oh, I don't want to list this. I'm going to, okay, that's fine. Your case will get dismissed or it won't be approved. That's your choice. But everything in bankruptcy is about disclosure. So when we're looking at these schedules, make sure that you have them filled out completely. As your attorneys, we can, I'm not an FBI agent. It's not my job to try to track you down and figure out what you're telling me or not telling me. That's not my job. At the end of the day, you are going to be signing those documents that says, under penalty of perjury, these are correct. So if you lie, if you don't tell me things, that's on you. That's not on me. So please make sure that when you are preparing, you're reviewing these things with your attorney, please make sure that you're letting your attorney know if there's things missing or need to be corrected, because these might seem like little things, but they can turn into big things for no reason. If you have any questions about bankruptcy, at least here in Georgia, I'm always happy to answer questions. My information is in the description below. Thanks.